Well, look, welcome everybody. We've got, I can see 108 people in the room, and I want to thank Brenda very much for joining us tonight. Brenda agreed to be a visiting fellow of LMH about a year before she stood down from the Supreme Court. And obviously we hoped that the first time that she came to LMH would be in person, but that's not happening, and it's very kind of her to join us in this unusual way. Brenda, I think you're in Yorkshire.
Yes, I'm on the outskirts of Richmond in North Yorkshire.
And you are indeed Baroness Hale of Richmond. So
this is true.
How has your lockdown been so far?
Well, of course, it's been a big change from what I was expecting, because I had loads of conferences, events, lectures, and so on for the first few months after I retired. But in fact, being forced to slow down, calm down, do a lot more reading and writing and cooking and cleaning and washing and so on, it's actually been very good for me. So yeah. Not bad.
Have you started anything new? You haven't suddenly started taking up the Welsh harp or embroidery or anything that you've been hoping all your life to do?
No, I haven't taken up anything new. I have started to write a new book, so that's enough.
You're not writing your memoirs?
Yes.
You're not writing your memoirs?
Yes, I am. Yes.
You are writing your memoirs. Oh, very good. Okay. Well, look, as I say, thank you for coming along and talking tonight. I thought I've taken, some people have emailed questions in advance. I'm glad to see that everybody is muted. That means you're all very well-groomed audience. I'm going to ask some questions, and if anybody who wants to ask questions, you can put them in the chat ribbon down the side. Then I'll either call you to come and ask them, or put them myself to Brenda. But one question, and I can't see if Ewan McKendrick's there. Is Ewan there? If not, I will ask this question on Ewan McKendrick's behalf, and I'm sure Ewan is known to Brenda.
Yeah.
But this was about your time in the family courts, and Ewan asked about your career sitting as a judge in a number of major family law cases, and he wanted to know the development from which you took the greatest pleasure in your time in the family courts.
Oh, in my time in the family courts. Yeah. Well, that's a bit tricky, because the family law development from which I take the greatest pleasure are the developments that are the result of my work in the Law Commission.
Right.
The legislation that my team participated in and which got enacted, principally the Children Act, but also the Adoption and Children Act and the Mental Capacity Act, those are the things which I take the greatest pleasure, rather than any particular decisions. And of course, as a family division judge, you don't get to decide an awful lot of law. Most of the law gets decided by the Court of Appeal and the House of Lords. As a first instance judge, you're just deciding the facts and applying the law.
I think Ewan's question encompassed your time as a law commissioner. Do you want to just talk about those changes that you've just mentioned, and how life of so many people, the lives of so many people have been changed as a result?
Well, I think particularly as a result of the Children Act, because the law was in a complete mess before we managed to try and bring it all together, so that the same courts, all courts were applying the same law, same, one hopes, coherent set of principles, same orders available. Cases could be freely transferred between courts to find the most appropriate level for them to be decided, all sorts of things like that, and a focus on the best interest of the child and the participation of the child wherever appropriate was also a change from the previous law. So there were lots of things about it.
And the second part of Ewan's question was, what do you anticipate to be the biggest challenge which lies ahead within?
Well, we have, of course, got a bill reforming the ground for divorce going through Parliament at the moment. And it's ironic because what's in that bill is very, very similar to what the Law Commission recommended in 1990. So, never give up hope as a law reformer. That one of these days your ideas might actually reach the statute book in an unmangled form. So I think that's something, obviously. The hope for that is to stop people having to make allegations against one another in order to get divorced quickly, and rather than having to separate for 2 or 5 years. So that's the purpose of that. That's a challenge. The biggest challenge of the lot is what we do about financial remedies in divorce, because we do have what I think is the best system, which is a flexible discretionary system, so that a solution can be tailored to the individual resources, needs, prospects of the particular family. But that, of course, if people can't agree, is extremely expensive to do properly. And that's the problem with all litigation. The best result is the one which can be the most expensive to achieve. And so should we have something cheaper and more cheerful, but less good? Or should we stick with what we've got, or try and improve what we've got? I think I'd be for improving what we've got, but that's just my general approach to things.
I might come back to that. When you first were appointed at the highest level, that was the House of Lords, and that subsequently became the Supreme Court. What difference did it make, do you think, to the way that you worked as a court? That change, because it was a huge change in some people's minds, but did it feel different being the Supreme Court member rather than a law lord?
The job itself was almost exactly the same. We were hearing cases involving points of law of general public importance. We were a 2nd, 3rd, or 4th tier appeal, not a first appeal. And we were hearing cases from all over the United Kingdom. So the actual role and jurisdiction scarcely changed. But it made a big difference to be in our own building, with courtrooms which we ourselves had designed, having offices which we had designed, having enough space for the staff, and being able to let the public in much more easily, have our proceedings broadcast, which they weren't in the Houses of Parliament, which is ironic, really. And it was extremely difficult to find your way to committee room number 1. You had to know where you were going, and there wasn't much room for anybody anyway. And we quite soon on persuaded council to stop wearing robes. So one way or another, the whole look of the thing changed quite dramatically, and with it, how it felt. More open, more transparent, more modern.
But at the same time, there were, or around the same time, there were a lot of differences that were happening in the relationship between Parliament and the courts, and the role of the Lord Justice, the Lord Chancellor, and the Minister of Justice. Does that feel to you as though this is still a very sort of fluid picture, or do you think that the situation that we now have will stand the test of time?
Well, I rather hope that it does stand the test of time. The main change was in the role of the Lord Chancellor, who stopped being head of the judiciary, stopped being in general charge of the justice system, although he still is in charge of the justice system, and stopped having the dominant role in judicial appointments. Those were the changes, as well as the Supreme Court. And I think as far as judicial appointments are concerned, most people think that the change is a very good thing. And as far as not having a member of the government as head of the judiciary, that was obviously an anomaly. The worry that people have is whether it means that the government is too distant from the justice system, doesn't really understand it, doesn't necessarily buy into it in the way that it used to do when the Lord Chancellor was head of the justice system, head of the judiciary, and a senior member of cabinet, so could speak up for the law. But of course, that's a typically British thing, isn't it? Only in Britain could it be thought that having such an anomalous situation was actually a protection for the independence of the judiciary and the rule of law rather than the reverse.
Okay, well, we might come back to that again in a different context. But talking of the test of time, Ewan's second question was saying that he'd be very interested to know that the case on which you gave judgment, which in time will prove to be the most influential.
Yes, and that's a really difficult question because, of course, it means looking into the future. You don't know. I mean, it's easy to pick on cases like the constitutional cases, you know, the two Miller cases, and say, well, those obviously were in their way hugely influential. But there are probably other things that will have had a greater influence on more people than those cases had. Things like the case which redefined domestic violence and the concept of violence generally. Now, the statute book has caught up with that in other ways now, in other contexts, but that probably was a case which will, in the end, have made a considerable difference. But no doubt there are many, and some of them will leap out and surprise us in the future. Be interested to know what Ewan thinks is. How Ewan would answer both of his questions.
Right. As I say, I can't see if Ewan, are you there? Make yourself known if you're there. I can't see that he's there, but anyway, I will ask him when I next see him. So moving on to Miller and first talking. Well, let's talk about the brooch first.
Oh yes, it's a B. It's not a spider.
It's a B, right? So did much thought go into the spider, or was that
no thought at all went into it? I'm not a Madeleine Albright, read my pins character at all. I have a lot of brooches. I started wearing them to liven up the rather sober garments that family division judges are expected to wear because they don't wear robes. And really a particular brooch tends to migrate to a particular garment and live there where it's happy. And so it's the choice of garment rather than the choice of brooch that dictates things. So
you were surprised by the concentration on the spider the day after?
I was very surprised by it. And probably if I'd foreseen it, I'd have worn something a little bit less dramatic looking. But there we go. And less open to interpretation about what I might be trying to convey.
I suppose a B would have been scarcely better.
No, it wouldn't have been any better, no. And most of my brooches are creatures of one sort or another.
So let's talk about consensus, because I think that was the thing that surprised a lot of people. And can you just talk a little about whether that surprised you, or how easy it was to achieve consensus on the day?
Well, obviously, I can't tell you very much about our deliberations. We were working under an enormous pressure of time. So after the first 2 days, when we'd heard from each of the parties, because as you know, there were two cases, there was the Miller case and the Cherry case. And so we'd heard from each side on each of the cases. I asked every one of us to put down our preliminary thoughts on each of the 4 main issues in the case: justiciability, if justiciable, principles, remedies and outcome, and put it down on 2 sides of A4 and circulate them at 9 o'clock the following morning. So not doing sort of competitive circulation, all doing it at once. And it became clear that there was a very substantial measure of agreement as a result of that exercise. And the 3rd day was devoted both in discussions between us and in what we asked the parties to talk about in court, was devoted to fine-tuning the criteria and the remedies. and the arguments. So it must have been apparent to all the parties in the afternoon of the third day that we were likely to find against the government, because we were asking for their further submissions on remedies. And we wouldn't have been doing that if we hadn't been likely to find against them, against the government, I mean.
When you're in charge of a court like the Supreme Court, how much does consensus matter to you? I mean, does it do legitimate differences on cases? Does that matter, or do you really try and get consensus?
There are bound to be differences, because by definition what we're dealing with is arguable points of law of general public importance, although some points of law are more arguable than others, undoubtedly. And we do achieve a pretty high degree of consensus overall, I think. And that's not through bashing people's heads together. It's just how it turns out. But there are some cases in which we simply cannot get consensus, and it's we have to live with the fact that we might be 3-2 or 7-4 or whatever, but that's how it goes.
One of our law fellows, Anya, has dug out a piece of research that showed that I think there was more consensus under you than under some other leaders of the House of Lords or the Supreme Court. And is that, do you attribute that to something about your style of leadership?
I have no idea.
No, okay.
I really don't, because one knows that Lord Diplock, for example, was a very authoritarian senior law lord. And yes, there was a high degree of consensus, but that's because people didn't stand up to him. Lord Bingham, on the other hand, was very anxious not to be authoritarian. Everybody could write what they thought, but he led very much by example, and he was such a good and persuasive lawyer that there probably was quite a high degree of consensus agreeing with Tom during his time. Less consensus under Nicholas Phillips, more consensus under David Newberger, I think, and more consensus under me.
Yeah. How important was it? I mean, it was obviously very important, otherwise you wouldn't have done it, but to have had all the justices taking that case?
Oh, in the Miller case.
In Miller too, yeah.
Miller too. In fact, with both of them, both the Miller cases had 11 justices, and we have to sit an uneven number. So that was all we could have, the maximum number of serving justices we could have. Well, we didn't, of course, want anybody saying that the result would have been different if different people had sat. In fact, as it turned out in Miller number 2, we were unanimous, so it would have been difficult to say that, but it seemed obvious to us that both of those cases were the two most important constitutional cases that the court had had. Yeah. And that's another reason for having the maximum number sitting.
Can I ask you a sort of very general question about the law, because it obviously touches on that period, but at the moment, we as the public are learning to think about something called the science, and learning that there isn't such a thing as the science. Science is not objective. And of course, as a journalist, the question of sort of objectivity and journalism is a very old and contentious subject. But can you talk a bit about the law and how objective, subjective it is? As a judge, are you conducting yourself in an objective scrutiny of what the law is, or how much does it vary on the personality and the beliefs of the judge?
Well, that's the sort of question that people debate with one another and with themselves, I'm sure, quite frequently, if they've got any sort of self-reflection about their role. You start with the law. I mean, there are certain fixed points in the law, and our job is to apply the law objectively, without fear or favour, affection or ill will. That's what we swear to do. So that's our starting point. But if you've got contentious areas of law where there might be more than one answer, well, then the answers that you come to may to some extent be influenced by your own values, your own experience of life, possibly your background. So that is why most of us argue that it's a good idea to have a diverse judiciary, because then you have a variety of backgrounds and experience feeding in to trying to work out the answer to difficult, contentious legal problems. So it is a bit of both. But what one hopes it isn't is just favoritism or prejudice or any of those sort of less lofty emotions.
And when you look at the American Supreme Court, which feels like a much more politicized arena, how would you characterize the difference between the way the British Supreme Court works and the degree of objectivity that the justices bring to it compared with the American system?
Well, we are fortunate in that judicial appointments are not made for party political reasons. I think that is generally accepted to be the truth, if only because governments of a left-wing persuasion would have found it very hard to find enough people qualified to become judges to appoint them. And so the general feeling is that since the Second World War, party politics hasn't come into judicial appointments. I myself got my first 2 appointments from Conservative Lord Chancellors and my second 2 from Labour Lord Chancellors. And then the presidency and deputy presidency came from an open, transparent competition before an independent commission. So I've experience of several different forms of appointment. And I do not know the party politics of my colleagues. I can make a good guess with 1 or 2 of them, but most of them I don't. And that is a shocking statement for any US person to hear, because they do know the party politics with which their Supreme Court justices started, at least. But being a judge, brings its own discipline with it. You'll find in the United States that some of the justices who were appointed by Republican presidents, in fact, turned out to be some of the most liberal, in American terms, liberal judges on the court. It doesn't always happen, but it does sometimes happen. There's something that gets to one. But no, we want to stay with the position that we don't know one another's politics, and our party politics don't influence how we decide cases. We want to stay that way if we possibly can.
I mean, the period around Miller II, which you must have felt very acutely, was so politicized and tempers were running very high, and you must have read some of the commentary after your judgment saying, well, if that's the way the judges want it, they've now strayed into politics, so we need to know more about who they are. Because I'm sure your instinctive reaction is to recoil from that, but do you think there's any merit in that argument that because to some extent background there are these subjective and personal influences, that it's reasonable for the public to say, well, let's know a bit more about where these people are and who they are and who their friends are and so on and so forth.
And how would that be done? Are we talking something like the US confirmation hearings that they have when the president has put somebody forward and has to go before the Senate Justice Committee and for confirmation? Are we talking about that? Or are we talking about something more journalistic that's done by the media? I don't exactly know what you're getting at. What I hope is that however much you tried to find out about a judge, it would never really tell you how he or she was going to decide a case. There was a good example of that, actually, in the journalism before the Miller #1 case, when one of the newspapers, I can't remember which one it was, sort of did an audit of the pro-Europe Europe credentials of each of the judges. And it was quite funny because Lord Reid, for example, who they gave sort of 5 pro-Europe stars to, was one of the 3 dissenters in that case. And that's a good example of how you can't, from various straws in the wind of people's experience, predict how they are going to decide a question of law, which is a question of law to be decided on the legal arguments, not on the political ones.
When you saw judges' headlines saying enemies of the people about judges, does that, I mean, as the most senior judge at the time, does that do you sort of brush that stuff off and think, well, that's just newspapers, or did you think that was a worrying straw in the wind that spoke to something?
Well, I wasn't the most senior judge at the time. Lord Newberger was president of the court at the time. But of course, because the case was coming to us, the Supreme Court couldn't make any comment about it. It is the role of the Lord Chancellor to uphold the independence of the judiciary. And there was a lot of disappointment at the time that the Lord Chancellor did not do that, or did not do that firmly enough or quickly enough. And it wouldn't have been difficult, because the script would go something like this. We have a free press in this country. You are entitled to write what you wish to write within the limits of the law, but it's my duty to tell you that you are wrong. These judges are not enemies of the people. These judges are doing the job that they have sworn to do, deciding the case according to law. Simple little script. And I might have gone on to say, had I been a politician, beware what you wish for, because you believe in the rule of law and you believe that people should generally be encouraged to respect the judges. And if you yourself show such disrespect for the judiciary, what are other people going to think? Might have said that too. But as it happened, there was such shock about that headline and about the failure of the government to respond to it appropriately, that by the time it got to us, it was, the fuss had died down. Yeah. We were not called enemies of the people. Actually, the newspaper in question did a very clever thing. They printed the photos of the 3 dissenters in the Miller 1 case and called them champions of the people, which I thought was quite a good, almost a joke against themselves. So it was, and the Lord Chancellor did put out a very supportive statement, as indeed did the Lord Chancellor after the Miller 2 case. So I hope that things will and have calmed down somewhat. It was, as you say, a very febrile time.
I have to ask you about your former colleague, Lord Sumption, who was, I mean, he did a very interesting series of Reith lectures, but which sort of really touched on the heart of the issues that you were deciding on in the Miller cases, and seemed to be really quite anxious about the extent to which judges were overreaching their proper. Not just in these cases, but in general. You'll be familiar with his argument that the Supreme Court has become too politicized, and that he would like to limit the role of judicial role to cases of real oppression, leaving other matters to be dealt with at a political level. What can you say about what you heard? I'm sure you heard those Reith lectures, and where you agree or disagree with him.
Well, I heard the Reith lectures, but more importantly, I read the book, which resulted from it. Yeah. And it's impossible in a conversation like this to give a proper and accurate response. I did do a lecture engaging with Lord Sumption's views, which has been published, and that says what I think about it. But as I understood it, what he was basically saying was that the judiciary are being asked to make decisions which really ought to be made by politicians. And he does sometimes blame the judiciary for going into areas that they shouldn't go into. And I've got answers to all of his examples about that. But I think his main concern is that the politicians are not solving the problems, which he thinks are better solved by political methods, by the give and take of politics, when there is give and take in politics, rather than by the binary solutions which the judiciary have to come to. You either win or you lose. In your case, that's how things are. And that's a very interesting point of view. I don't think he said anything in the book that really was relevant to the Miller litigation, because he would accept that it has always been the role of the judiciary to ensure that the government stays within the limits of its legal powers. That's the principal feature of the rule of law, which he would defend as strongly as I defend it. So none of the examples that he gives relate to the Miller judiciary. They relate to other things.
I did a very interesting conversation, LMH conversation with him, in which he couldn't see any contradiction between his prior commentary on Miller 2 and his subsequent commentary on Miller 2, but
yes, well, that's what I mean, you see.
We're talking against the background of extraordinary events in terms of race and the Black Lives Matter movement. You've talked a bit about diversity in the courts and in the judges and how much that matters. What's your answer to, I mean, both in terms of gender and ethnic diversity, as to why the progress has been so slow in getting the kind of courts that you would like to see?
Well, there are two different challenges, I think. There has been recently much more success on the gender front. And that is partly because women have been entering the legal profession in large numbers for several decades now. And there is still in all professions, there's a huge attrition problem, that women tend to step down, step backwards, step sideways, and don't continue in the self-employed legal practice, which is what normally leads to a career in the judiciary. But we are getting much better at recognizing other forms of a legal career which could qualify one to become a good judge, much better at getting women to put themselves forward now that we've got an open and transparent application-based and merit-based program. I think we're getting much better at recognizing merit. So the proportion of women has grown very considerably over the 10 years that we've had the Judicial Appointments Commission system. I think we're now up to a third in the High Court and Court of Appeal. And until I retired, we were a third in the Supreme Court too, but now we're down to 2 out of 12, which is unfortunate. So I do think very considerable progress has been made. And if it continues at that rate, it won't be very long before we have gender parity in the judiciary as a whole. The ethnic minority problem is greater, partly because it's more recently that large numbers of people from various ethnic minorities have been joining the legal profession. And it's partly because the barriers in the different ethnic groups may be different. They all face different sorts of discrimination and different sorts of problem, and how we manage to get around those is, I think, tougher. But there is a considerable will now to do it, which there wasn't. 20 years ago, there wasn't. People were really very happy with how things were. They thought, we've got a brilliant judiciary, we've got the best judiciary in the world, so of course we don't have to do anything about it. And of course, if they did do anything about it, it would actually mean that fewer privileged white males got appointed. And maybe there were people who didn't want that. But I think there now is a genuine desire to improve matters, which is producing results. I was told by the senior president of tribunals that in the tribunals system, they have actually now got, both on gender and ethnicity, proportions which roughly match those of the working population of that age in the general population, which, if that is the case, that's a brilliant achievement, and it shows it can be done. Sorry, I'm being a bit Pollyanna-ish, aren't I? But
well, that's fine. We're all so depressed by lockdown. A bit of Pollyanna-ish doesn't go amiss. Now I know from people who wrote to me before. So Ruby Gardner, I hope you're there because you wanted to just ask a question touching on diversity. So there you are, Ruby. So Ruby was a law student here. Ask your question.
Hello. Thank you very much for doing this talk. It's amazing to have to ask you a question. So I suppose it links on to the barriers faced by ethnic minorities. And a potential barrier may be because of the disproportionate sentencing of BAME people in the criminal justice system. For example, the 2016 report by the government said that black women were 25% more likely than white women to be sentenced to custody. And BAME adults are more likely to receive custodial sentences in the Crown Court. And if this is potential barrier to people of colour entering either the legal profession or policing, I was thinking, why do you think this exists, this disproportionality, and what steps could be taken to maybe reduce this?
Well, I'm not sure that particular problem is one of the barriers to BAME people entering the judiciary, because on the whole, any sort of criminal record, whether or not it has resulted in a custodial sentence, is likely to prove quite a barrier. So I don't think that's the particular problem, but it is a problem. There is no doubt about that. And there have been lots of recommendations made by people better qualified than I as to how to address disproportionate impact of the criminal justice system on the different BAME communities, but I think particularly people of African or African Caribbean heritage, frankly, it's greater there, and how that can be addressed. Obviously, educating the judges to be more understanding is an important element in that, and constant reinforcing education of the judges. And we do have equal treatment education, but it needs to be pressed home. Trouble is, sometimes people are a little bit reluctant because people don't believe that they're prejudiced, even if they. So you have to recognize that you have all sorts of biases which are unconscious, and try and ask yourself, how can I bring them to my consciousness and try and get round them. It's a constant thing. I mean, it's true with all sorts of biases, but that's, I think, the most obvious and apparent. I mean, the figures are really quite shocking. And the disparate use of stop and search. And
yeah.
When you get somebody like the recently retired Archbishop of York, who was regularly stopped, not necessarily searched, but stopped by the police when he was out and about, you think, what's going on there? So we do have to try very hard to look for solutions. But you're going to do all right, aren't you?
Yeah, I mean, I was sort of first apprehensive of maybe pursuing a career in law because of the levels of distrust and sort of feeling maybe the judiciary or legal profession isn't something for me because of what I read and the figures and the statistics. But that's really interesting what you say. Thank you for answering.
Well, we need people like you to join the profession, well, there are growing numbers of brilliant BAME lawyers, and we're beginning to make a start in the judiciary. It's very slow, but we have got some very good lawyers who've joined the judiciary. So I have to keep up my Pollyannish attitude, mainly in order to try and enthuse people like you.
We're rooting for Rabinda, who was also a visiting fellow before you. Mariana, you're a law finalist. It's a slightly changing tack, but I'm keen to get the students in to ask questions while they can. So Mariana, please.
So the first question I sent you, Alan, was something that Lady Hale touched on at the start about discretion in Miller and Miller. But I had another question. I was really interested in the Supreme Court decision in Radmacher and Grantino, and especially your very brave judgment in pointing out that the male judges were sort of ignoring the gender equality issues concerning the cases of prenuptial agreements. In light of such statements, which in my view were completely accurate, what do you think are some of the key reforms in family law that would promote the gender equality that is needed?
Well, that's difficult, isn't it? Because it was unfortunate that the prenuptial agreement question came up in a case where the victim, if one wants to put it that way, was actually the husband. Because I have little doubt that amongst at least some of my male colleagues, the idea that a husband should actually be asking for a share of his wife's enormous fortune was something actually that men shouldn't do. Whereas if it had been a case where the person disadvantaged was the wife, I think, I could be wrong, that the views might have been a bit different. And they might have recognised that these agreements are always designed to make sure that somebody gets less than they would otherwise be entitled to. That's what they're for. And so you have to ask, what safeguards do you need to make sure that somebody realises that when they're making such agreements? And they went ahead and said that they're not binding on the court, but they were nevertheless legally enforceable agreements without saying what safeguards were needed. And so, yes, I felt strongly enough to draw attention in print to the gender issue. There is still quite a strong pressure to legislate for prenuptial agreements. The Law Commission came up with, I think, some respectable proposals, which were that you could never have an agreement that absolved the person from the duty to provide for their spouse's needs, and said that there had to be various safeguards which had to be proved by the person wanting to enforce the agreement. Now, I think that is acceptable, but there are other proposals which are very much less acceptable in that area from my point of view. So, but I think it would be probably a good idea to try and improve that position as a result of the red matter in Granadino. And of course, the other problem, as I've been saying earlier, is the flexibility of our financial remedies law is a good thing. And in particular, it's a good protection for women who have, for whatever reason, compromised their standing in the marketplace for the sake of their families, which men do too, but women do it far more often than men do. And our system is designed to compensate them properly for what they have done. Now, but the trouble is, it costs a lot of money. And if people want to fight, and particularly if one of them has more money with which to fight, it's a problem. And I really don't know the solution to that, because I would like us to stick with the flexibility that we've got, but I'd like us to find ways of it's not costing quite so much so to do. Thank goodness I'm no longer in law reform. Of course, the other difficulty that we have is what to do about all those people who don't get married at all.
Yeah.
But who lead their lives as if they were married. And so land themselves in exactly the same problems if the relationship comes to an end, whether by separation or by death, as they would have if they'd been married. And that's another problem that we need to do something actually quite urgently to sort out.
Wouldn't you say that the legal uncertainty is actually worse for unmarried couples, since they have to go into property law and trust law kind of disputes, and it gets really complicated for them?
Well, it is worse. It is worse because, in fact, unless there's a really bitter fight, the financial sort out for most married couples is pretty straightforward, because it's fairly obvious what's going to happen. And if you've got sensible legal advice on each side, I mean, that's another problem. You need sensible legal advice on each side, because the lawyers sort out the problems. People tend to think that the lawyers create fights. Generally speaking, in family law, they don't create fights. They sort out the problems. It's very much more difficult for people who are acting for themselves to sort out what the right solution. For a start, they don't know what the law is. They don't know what the right solution is likely to be, and they can't really talk to one another in the way that two lawyers can talk to one another. So that's another thing I'd like to see put right. But there we go. Yeah. But you're right that for the uncertainty or the complexity for unmarried couples is much greater, because you can't look at things in the round. You can only look at what happens to the house. You can't look at other sorts of savings and assets. Can't look at earning capacities and so on. So there are all sorts of things that you cannot do, which you can do if you're married. I don't know why people don't get married. I really don't.
Thank you so much for your answer.
Ria,
thank you. Thanks for your question.
Ria Chopra, you put a question in the ribbon. You're a first-year law student, and I know it's going back slightly over the thing that we were talking about, but come in anyway.
Sorry, I think my video is not working. But basically, as a first-year lawyer, one of the subjects that we study is constitutional law. And we've had a lot of discussions about the interplay between the rule of law and parliamentary sovereignty, and kind of whether there is some kind of more ultimate principle that does guide the Constitution. So I was just wondering what your view on that is, and whether you think one is more important or whether they just work in tandem.
Well, I think they normally work hand in hand. As a general proposition, most of the time. You probably know a little throwaway remark in brackets, in my judgment, in the Jackson case.
Yep, maybe.
Well, because there were much more explicit statements by Lord Steyne and Lord Hope in the Jackson case, to the effect that there might be limits to what Parliament could, in fact, do.
Yeah.
And particularly, Lord Hope said the rule of law is actually the governing principle of our Constitution. And if Parliament set out to subvert the rule of law, basically by excluding the courts from deciding disputes, particularly disputes between citizen and state, well then that would be unconstitutional. That is a view that Scots lawyers have actually held, as you probably know, for some time. That they believe that the Scots didn't believe in the sovereignty of Parliament to the extent that the English did. And there is no reason why the Act of Union should be taken to adopt the English view rather than the Scots view. Well, we English try and keep quiet about that. There are quite a lot, not a lot, but there are some principles of statutory interpretation which mean that most of those acts of Parliament which look as if they have been taking away the jurisdiction of the courts have one way and another been found not to do so.
Yeah.
Well, I can think of 3 examples. 3, certainly 2 in my time. The Prince of Wales letters case, and the Privacy International case. And there is another one. It's at the top of my head, but it'll come out. And there were different reasons in each of those cases. They were very different cases, but they were cases in which the legislation was interpreted in such a way as to mean that the jurisdiction of the courts to decide what should be done wasn't ousted. So, yes, it's a continuous debate, and it will go on, no doubt, but most of the time it works all right. Does that make sense?
Does that make sense? Can I bring in Charlotte Ashmore? Question about foreign judicial decisions.
Yeah, thank you, Alan. My question is pretty straightforward. In one of my courses that I do in my Masters of Law, we discuss, I suppose, the benefits and the criticisms on referring to foreign case law when interpreting domestic law in other jurisdictions as well as the UK. And I wanted to ask whether you have any strong opinion one way or another on whether it's legitimate, and if so, when courts should rely on foreign case law when they're supporting their own decisions.
That sounds like a very American question.
Yes, we look at a lot of US court law definitely in our analysis. So yeah.
No, I was just thinking that was that's a very controversial question in the United States.
Yes.
The use of so-called foreign law. It's not a controversial question here at all. Obviously, there is certain so-called foreign law which has, until last year, been binding on us. So we had to look at the judgments of the European Court of Justice of the European Union. We had to do that because an Act of Parliament had told us that it was binding on us. That's what an Act of Parliament had said. We don't, and we obviously, when we're interpreting the Convention rights under the Human Rights Act, it makes sense for us to look at what the European Court of Human Rights has said about the issue, because if it's clear that somebody is going to win in Strasbourg, it doesn't make a lot of sense for them to lose in the UK, if that's clear. If it's not clear which way it's going to go, well, then we can try and deduce the principles that Strasbourg is likely to apply and do our best with it. So we're bound to look at what Strasbourg has said. Not necessarily follow it blindly, but look at what they said. When it comes to decisions of truly foreign courts, then if it's a question of the application of an international treaty, where there isn't a supranational court to tell you what the answer is, again, it makes sense to see what other parties to that treaty are doing, how they're interpreting and applying the treaty, so that if possible, all the parties are doing the same thing. So if it's a trade treaty, we will look at what the United States is doing, for example, in relation to trade treaties. We don't tend to look at what the United States is doing in relation to things like fundamental rights, because obviously the Bill of Rights is so different from any of the modern human rights instruments that they're not as instructive as what's going on in, say, Canada. But yes, with treaties we will look. With the Hague Conventions, for example, on child abduction, we will look to see what the other countries that are parties to that treaty are doing, so that we are, if possible, all doing much the same thing. Can't always do that. Actually, with child abduction, we tend to be ahead of the game on that, and we find that the US courts are following what we have decided on the child abduction treaty. If it's a question of the common law, well, we will look at what other common law jurisdictions have done with a knotty problem, and see whether they seem to fit with how things are in this country. So that we call them persuasive authority, not binding, but we wouldn't want to get too far out of step with comparable jurisdictions, by which I would tend to mean Canada, Australia and New Zealand, the principal ones which are comparable to the UK. So we're perfectly happy to look at foreign law. We don't always follow it, but we're very happy to look at it because it can be helpful and instructive. The difficulty is not always knowing the legal context, because especially when it comes to a common law question, the common law may have developed rather differently in those jurisdictions from how it has developed in this jurisdiction, and we may misinterpret the meaning of the decision in the foreign jurisdiction. So we have to be very careful about it, but definitely can be helpful.
Brenda, we promised that we would keep this to an hour. I've got one final question. Well, actually, look, Zara's just popped up a question. I'll come to my question. We may get to an hour and 3 minutes, but Zara, do you want to just pop up and ask that question there?
So my question is just about legal reform, which you've already talked about, of course. And my issue is that my question is about when it comes to social issues, maybe the environment, labor law, or modern slavery, or like immigration, we often say these are party political issues, where to me it seems like they are the things that the law should first and foremost want to protect, if we think about human rights conception of rule of law. And my issue is that the court, I feel, takes too much of a deferential approach, and of course says, it is sometimes for Parliament, but I don't know if that's adequate when it comes to social issues, because it's where the saying justice delayed is justice denied rings most true. And I was wondering what your thoughts are on the current state of legal reform and how we could even go about reforming the approach to legal reform to
Oh, that's an enormous question, isn't it?
Sorry.
I think I would distinguish between social issues and issues of fundamental rights, because which sometimes involve social issues, but fundamental rights are there to protect individuals and sometimes groups against invasions of their fundamental rights which have been sanctioned by the majority. That's their purpose. It's to protect individuals against the majority. And I think it's very important, therefore, that we continue to uphold fundamental rights in that sense, because they're there to try and guarantee a degree of equal treatment for everybody, no matter who they are and where they come from. Social issues, it all depends what you mean by a social issue, doesn't it? I mean, if you mean who should get what welfare benefits, well, then that's the sort of thing that really has to be decided by the people who are raising the money, which is Parliament and the politicians. And but there are other sorts of social issues which judges properly get involved in.
Like earlier on when you were speaking about Law Commission and the Children's Act and how it took, it's something that was recommended in 1990, but is only realised by Parliament in 2020. Or I don't do family law, but
that was the ground for divorce,
mm-hmm.
And we made a recommendation for replacing the ground for divorce, which was put into an Act of Parliament, but it was so complicated and so they put all sorts of bells and whistles into it, which meant that it was unworkable, and so it never got brought into force. So it is quite nice that they are planning to do it now, quite satisfying. But there are a lot of things that are social issues which probably ought to be dealt with by Parliament. The most difficult thing that we had in the Supreme Court was when we had discrimination issues in relation to social welfare benefits. Were they unjustifiably treating one group worse than another group? And could we say that that was unlawful discrimination under the Human Rights Act? Those were the most contentious cases that we had in the Supreme Court and the most difficult to resolve.
Thank you.
So Brenda, my last question was just about the person you're most often compared with, which is Ruth Bader Ginsburg, and I know you know her and she's a friend. Can you just talk about why you admire her as a lawyer, or something about her personal qualities as a friend?
Well, I certainly admire her as a lawyer. Of course, she was a co-author of the first textbook on sex-based discrimination law, now way back in the 1970, I should think it was, something like that, with somebody else whom I greatly admire, Herma Hill Kay. The US approach to discrimination is not the same as our approach to discrimination, but nevertheless, she's a very firm upholder of concepts of equality, which I very much admire her for. I love some of the things that she says too. You know, when she was asked, when will there be enough women on the US Supreme Court? And she said, when there are 9. Yes, well, we laugh, don't we? But it's always been thought there are enough men on the US Supreme Court when there are 9, or on the UK Supreme Court when there are 12, or whatever. So in a way, that's the sort of thing that her steely adherence to the principles she believes in.
We're out of time, so first of all, apologies. There are so many interesting questions in the chat line, and really we could do 2 or 3 hours and still not exhaust them. So thank you for those who have asked the questions. Thank you, Brenda, for doing this. Thank you for agreeing to be a visiting fellow. We look forward to welcoming you in Oxford and to talking again. Good luck with your book. It's bound to be a fascinating book on the basis of what we've heard today. Thank you for being so generous in your answers and so straightforward and frank. Somebody in the chat line has said, can we talk about the next events that are coming up? There are 2 that we haven't got dates for, but have been confirmed this week. One is Sir Hilary Beckles, who is the Vice Chancellor of the University of the West Indies, who gave a very interesting lecture here in 2016 about the issue of reparations and roads must fall and so on and so forth. So he's going to come along and speak. And the other is Professor Sumakai Chikugu, who is the professor of African politics here in Africa, who wrote in Oxford, who wrote a very interesting piece in The Guardian this week on similar matters. So we're going to arrange both of those hopefully in the next couple of weeks and keep you posted as to the dates. But for tonight, Brenda, that was fabulous. And thanks for an amazing career in legal reform and as a trailblazer of reform and example generally to our students, but also for all that you've done for the law. So thank you.
Thank you for, it's been great fun. We could have had a whole hour on each of the questions that have been asked. That's the problem. But anyway, it has been fun. Thank you.
When you're finally allowed to travel and you can come to Oxford, we can resume the conversation. Thank you so much.
Yes.